Hey everyone, welcome to another Talking Feds one-on-one. It's the first week in October, but the crisp fall feel of a new Supreme Court term is less pronounced than in past years because the court was so active over the summer, most notably delivering a series of victories to the administration on its shadow docket without full briefing or oral argument. Or I really should say the court's conservative supermajority, because the 6 conservative justices, for the most part, joined together in the endorsement of Trump's claims, at least to the extent of dissolving stays on them in the lower courts. Now we are back with a full term of argued cases, some of which will give the court the opportunity to dramatically transform longstanding constitutional rules, and with them, the daily lives of all Americans. To preview the important trends in the term ahead, and in particular, analyze how they may dovetail with the authoritarian agenda of the president, we're really fortunate to be able to welcome one of the most knowledgeable and trenchant Supreme Court commentators in the country, Kate Shaw. Kate is a professor of law at the University of Pennsylvania Law School and co-host of the gold standard Supreme Court podcast, Strict Scrutiny, among other distinctions. And I just want to name 2 because they're germane. She was at the White House Counsel, which had to do with a lot of litigation with different agencies, and she clerked at the Supreme Court for Justice Stevens. Kate, thanks so much for joining Talking Feds one-on-one.
Thanks for having me back, Harry.
Okay, so where to start? I think we can't just jump in with the big cases for the term, as is traditionally done, without a few words about the court's busy summer, when the court repeatedly sided with the administration in circumstances that, while technically are provisional and temporary, basically settled very big questions involving his assertion of outsized power and his superseding of legislative power. The progressives issued, plaintive dissents, but really couldn't combat 84% of the Trump administration's emergency motions, which are already much more plentiful than past administrations, prevailed. When you were in the Obama counsel's office, it was closer to 50-50. So what's your take on the court's use of the shadow docket over the summer?
Well, I'm so glad we are not just pretending this is a curtain raiser on a Supreme Court term that is like any other year. I mean, that is sort of standard fare. We sort of sit down and talk about the big cases the court is going to decide and sometimes identify some major themes. But it's not as though the last term has really ended, right? We basically, up until the eve of the new term, the court was handing victory after victory to the White House and to President Trump. And you're right, these victories have been technically temporary. So when a party prevails on the shadow docket, what the Supreme Court is doing is weighing in on what the status quo will be while litigation proceeds, maybe up to and including Supreme Court litigation. But allowing the administration to proceed even temporarily in some of its efforts is essentially the whole ballgame. So if you let the president dissolve the Department of Education temporarily, that's letting the president dissolve the Department of Education or fire officials or refuse to spend appropriated billions of dollars. And so, I think you're right to highlight everything that's happened on the shadow docket over the summer. And also, I think we should note that we can talk about a couple of the cases that the court has already agreed or, already actually heard arguments in, but there's going to be more activity on the shadow docket over the course of the next year as well, in parallel with the merits docket. And in some ways, what is most important right now is what is happening on the shadow docket.
Yeah, that's a great point. I think there are 4 or so out there. And I'll just add a couple points. That's true. So totally true what you say, both because of the different timeline of legal cases with events in the real world. So by, in 18 months, were things to be reversed, what Department of Education?
Yeah, exactly.
Right. But also the court habitually opines in order to grant its temporary stay or remove stays that one party or another is likely to prevail on the merits. So they would also have to totally shift gears and, put it in reverse going 50 miles an hour or whatever, and it's just not too likely. Yeah. All right. So much more to say about that. But I, and this for listeners too, I want to really make fairly quick work of what Kate says would be the traditional preview of the term, because there's some big ass questions I really want to get to. So let's talk about the docket. My poor listeners have been hearing for months about Humphrey's executor and the like. But, the fate of independent agencies, A, is it preordained? Is Humphrey's executor dead? And B, what are they doing? And is there any principled rationale to the one exception that seems to remain, namely the Fed?
So what are they doing? Yes, I think they are, on the way to dispatch poor Humphrey's executor and to formally overrule it, which they have come close to doing but have not technically done. And so I think they'll do that in the case actually involving the same agency as Humphrey's executor. That's the Slaughter case involving the Federal Trade Commission. But your question is, so, the court so far has granted the president the temporary power to fire every head of an independent agency that he has sought to fire
without cause, just willy-nilly.
Yeah, just because he wants someone else in that position. And so remember, these are agencies
or Laura Loomer does,
or right, some part of the Trump coalition does. But we're talking about the National Labor Relations Board, the Consumer Product Safety Commission, the Equal Employment Opportunity Commission. So I just want to underscore these cases are about presidential power, but they're also about, in your intro, I think alluded to this, issues that really do touch basically all of us, right? The safety of the products, that the cribs we put our children in. That's the Consumer Product Safety Commission. It is by design a bipartisan expert body. Trump says, no, I want to be able to install my people at the head of that agency. And so far, the court seems to be poised to completely grant him the unfettered authority to do that. That's true about the National Labor Relations Board, which, both protects unionization, but also protects workers more broadly, not just union activities. And the list is very long. Okay, so those are most of the agencies. But of course, you're right that the big question is the court going to carve out an exception for the Fed? And is there a defensible argument that the Fed can be carved out from the rest of these independent agencies? So the Fed is in some ways very similar to all these agencies that for over 100 years, Congress has created with a degree of independence from the president, because the idea is there are certain kinds of government functions that we want discharged by independent, bipartisan experts who have a degree of insulation from the political whims of the president. And that was a choice that Congress made beginning, in the late 1880s and has made in a series of agency kind of design choices since. Okay, so then the Fed is like those other agencies in that it is a multi-member body where the governors have these terms of years that don't align with a presidential term. So every president has been saddled with a Fed, this central bank that has on it some people the president or somebody of the president's party, a predecessor president picked, and some people the president would not have personally selected. And again, that is by design. And as important as those values are with all of these other agencies that I just mentioned, it's always been of even greater importance that the Fed be genuinely independent from politics so that it can make decisions about things like interest rates, which obviously intersect closely with inflation and prices, with an eye to the greater economic health of the nation and not with an eye to the political fortunes of the president. And that is a core value, Fed independence, that presidents, whether they have liked it or not, have basically honored until this president. So this president, people will remember, made noises on the campaign trail and after assuming office about potentially firing Fed Chair Jerome Powell. Maybe, because just he wanted to, but he also seemed to be playing with the idea that he would try to manufacture some kind of cause. Because I should say, maybe I haven't said this clearly, you sort of alluded to this, these are not statutes that prevent the president from firing heads of independent agencies. They just require the president to have a reason and to state the reason. Various versions of the statutes look different, but they're all some kind of good cause requirement. And actually, the Fed statute just says for good cause. That's really all that's in the statute. So the president seemed like he was maybe trying to build a case that he could, for cause, fire Jerome Powell, maybe because of cost overruns in a Fed building renovation, but seems to have decided to pull back from that because it just wasn't plausible, and instead to seek to fire another Fed governor appointed by a Democratic president, Lisa Cook, on the ostensible grounds that there was fraud in a mortgage application that the president has claimed two separate mortgage applications claimed two separate residences as primary residences in order potentially to get favorable interest rate treatment. So can the president say, or can the court say rather, maybe the Fed is different because the history of the Federal Reserve Bank, which traces back in the court's view to the first and second national banks, distinguishes it from other independent agencies? Or maybe the court could potentially, say the Fed actually can't be distinguished from other independent agencies, and the president, either for cause or even without cause, can summarily remove people from the Fed. So I think there's going to be, my view for what it is worth is that it's very hard to draw a principal distinction between the Fed and the other agencies. The court might try to manufacture one by pointing to ostensible distinctions between these agencies. But if it does that, it's really going to be doing it because it is concerned about what it would do to the U.S. and global economy to give the president unfettered access to the, appointing, filling the seats on the Fed, rather than because there is a principled legal basis on which to distinguish the Fed.
Yeah, look, I totally agree with you. They've had this project for over 10 years of trimming back agency after agency. This one only has one member. This one exercises prescriptorial power. But where they are now at these, everything we learned in law school, you can rip out that chapter for your students or future students about what independent agencies, and let me take an aside on this aside. Justice Kagan, who knows administrative law better than anyone, has made this point very well in dissents. We are talking about agencies and a structure of government that is a little ungainly, perhaps, but has served the country very well since the New Deal, that being all thrown out the window. And to me, the Fed is there flinching. It's basically like, well, if he messes around with the NLRB, we'll be okay. But here, the world economy and the national economy would go down the drain. But, that I think shows that they're doing it for unprincipled reasons. Anyway, we will see. And I think it's a genuine question whether they'll try to have. I'm reminded when I clerked of Chief Justice Rehnquist saying about the Penn Railroad exempting them. And so that was a really big railroad. And here they've said likewise about the Fed and was it Trump v. Wilcox? Oh, that's and they gave things that described the Fed, but certainly didn't distinguish it. So anyway, we'll see.
Yeah, can I just jump in? Yeah, it was Wilcox. And just to come back to Kagan, in another case, not the case involving the Fed, but a case involving the way the Consumer Financial Protection Bureau is funded, Justice Kagan basically made the point that you were making, and I just want to quote her. She basically said, there was an argument, well, does everything we're saying about this other agency, the CFPB, also mean there's a problem with the Fed? This wasn't about the heads of the Fed, but the funding of the Fed. And the party challenging the CFPB sort of tried to backpedal, and Kagan said, right, because the Fed is just too important or whatever, not that there's a real difference. And I think that essentially is the question. Is the court going to say the Fed is too important or whatever? And is that recognizable as legal reasoning? I would say no.
I would say no also. All right. One more quick important executive power case that's coming up is his attempt to impose tariffs all over the world willy-nilly. He says the International Emergency Economic Powers Act, emergency, it's always an emergency, lets him regulate importation of foreign goods to a lot of people, including courts of appeals. Sure, walks like a tax, quacks like a tax, and that, taxation being Congress's quintessential power. How do you think they'll approach it? Will they employ the major questions doctrine? How do you see this really big question that also, more than the other, encompasses a big theme of Trump 2.0, namely the complete, not just arrogation of big power, but the subsuming of congressional power. How do you see this playing out?
Yeah. So the statute that you just mentioned, Harry, IEPA, I'll call it for short, is a statute from the late 1970s that gives the president certain authorities when the president declares an emergency. And I think there are, so there is a deep question, which is whether that statutory authority even gives the president the power to impose tariffs at all, because tariffs are, do obviously function like taxes. Taxation is a power that belongs to Congress and not to the president. And also, this is a textualist court, at least on its own telling, and there is no explicit authorization to impose tariffs in IEPA. There are other statutes in which Congress has delegated to the president the power to fix tariffs. Lots of them, actually. Once upon a time, there was a lot of argument about whether those violated something called the non-delegation doctrine. But the court had basically decided that so long as Congress gave the president guidance about how to decide what these tariffs should be, it was okay for Congress to sort of share some of that authority with the president. This statute doesn't say tariffs. So there is an argument that the Federal Circuit actually didn't even reach, that the president has no authority to impose tariffs at all under the statute. The question on which the Federal Circuit ruled against the president was essentially whether these asserted emergencies satisfy the statutory standard. And all the president has really pointed to in his court filings, which are distinct from his public, telling about these tariffs, is essentially this finding that there are these trade imbalances between the U.S. and lots of trading partners, and that those imbalances constitute an emergency, and that courts don't really have the power to probe that determination by the president. And that is a theme that I think, goes far beyond this tariffs case, right? When the president says emergency and makes some very, offers some very thin explanation or justification for the finding. He doesn't just say the word emergency. He a little bit tries to explain or support it, but these are very, very thin, maybe frequently pretextual justifications.
Yeah, maybe
but do courts
actually,
have a role,
in the words of our, untethered to the facts, you might even say, right?
Correct. Exactly.
This to me is the biggest hovering question out there. Will they greenlight some kind of emergency proclamation, even though the courts know he's lying, not to put too fine a point on it, on the notion of deference? That's why I was buoyed by Immerget's opinion in Portland saying, yeah, I got to give deference. That's not the same as rolling over. Let's move quickly, at least just a few minutes, on some of the hot button social issues. The court has 3 LGBTQ plus cases, including 2 on transgender athletes, which the NCAA reports there are 10 in the whole NCAA, but it's taken on this outsized symbolic importance. I wanted to ask you about the one big case that's been heard so far, the Childs case, which they took up, I think it was on Monday. And you have a religious therapist who wants to be able to counsel people with gender dysphoria to stay with their biological identity, in large part. It's part of the record because of sort of religious reasons. And Colorado has determined that trying to do this by any means is really injurious to health causes in the short term before puberty ends. If you do that, can cause depression, suicides, and the like. So they see it as like just regulation of medicine, same as you would tell doctors, you can't prescribe Latril, you can't do, wacky kinds of things. And I just want to add quickly that last year, as you know, in the Scrutiny case, the court green lighted the way for Tennessee to actually foreclose certain kinds of treatments. That was on the conservative side. So I don't know if you listened to the argument, but just in general, I wanted to ask you about Childs and anything you want to sort of amplify with respect to the other, both the other LGBTQ plus cases and the sort of religious freedom hot button cases that may be coming down the pike.
There's lots to say. I'll try to be brief. Yes. I mean, I did listen to the argument yesterday in Childs versus Salazar, and you're right to connect it to Scrutiny, the case out of Tennessee, right? So last term, the court deferred to the state of Tennessee and its legislature when they decided to ban certain kinds of medical care that the state decided was inconsistent with the sex of the child. So gender-affirming care for children can constitutionally be banned in the state of Tennessee. So you have the court there basically saying, states, you decide. But of course, along comes Colorado that has made a very different decision. And it said, we are going to ban a certain kind of care, but we're going to ban it in an effort to protect, right, both trans, but also gay and LGBTQ individuals, not just children, but adults, because there is tons of evidence and really, I think, a pretty strong scientific consensus that this kind of therapy is actually very damaging for recipients of that therapy. So
it was strange that there was a dispute about this at court. It should have been worked out, Barrett in particular. Yeah. But every major medical organization just says, these are terrible outcomes.
And we do ban certain kinds of interventions that are dangerous and destructive to patients.
Latril, whatever.
Yeah. And yet, despite the fact that on their face, you would think these come down the same way if this is a court that's going to defer to legislatures when they make decisions, it did not seem coming out of the oral argument as though the court is going to apply that sort of principle. Now, we should say these were different constitutional challenges. It was an equal protection challenge in the Tennessee case. This is a First Amendment challenge, right? This therapist and her legal team say that it is a First Amendment violation for the state essentially to prohibit her from providing a certain kind of talk therapy, as the argument kept describing it. But you're right, I think, Harry, that it's a First Amendment speech claim, not a First Amendment religion claim, but it's a speech claim with a heavy religion overlay, which was exactly the same presentation as the 303 creative case from a couple of terms ago, where the court sided with the speech claim of a would-be wedding website designer who said she didn't want to design websites for same-sex couples because it would be compelling her speech. But the reason she didn't want to provide what, she said was this kind of speech was sort of a religiously grounded objection to same-sex marriage. And there, despite lots of standing questions about whether she should have been in front of the court at all, she won. And this, another case out of the same state and a very similar theory and the same legal team representing the therapist, I think is very likely to come down the same way. And honestly, I was kind of hearing certain strains in the oral argument that made me think there's a chance this isn't even just a 6-3 win, but a bigger win in which, at least in concurrences, it's possible that one or more of the Democratic appointees goes along on the basis that this is viewpoint discrimination. And in the same way, you would not want a state in the age when, the DSM said that being gay was itself a mental illness. Yeah. You wouldn't want a state to be able to prohibit therapists from saying to, a gay patient, no, you're fine, you're wonderful the way you are, but allow them to try to counsel people out of being gay, that somehow that logic means here that any kind of intervention, even if supported by scientific consensus, is viewpoint discrimination and has to get a very skeptical look and likely be struck down. So that, I think, unfortunately, is where this case is likely going.
I mean, Kagan presented almost as a syllogism, what seemed an argument for viewpoint discrimination, especially because the court has more or less said, there's a little room, but that, speech by providers is the state gets no less protection under the First Amendment. But I agree with you. It's a whole different episode. Maybe we'll have it one day or part of one about the strategic calls of the three. Like, a few terms ago, Kagan went along with an Establishment Clause case on this grandfathering rationale that I think was her way of cabining damage, et cetera. So, but anyway, that's a whole different point.
And she's done it a few times. And I think they're real strategic questions.
Look, she's a strategic operator.
Absolutely.
Talking Feds is supported by the Brennan Center for Justice. In this new political era, the Brennan Center will do what they do best: defend the Constitution and the rule of law. They're prepared to fight against presidential overreach and will continue advocating for reforms to resist weaponized government, stop billionaires from corrupting our elections, and ensure every eligible American has the freedom to vote. Stay informed by visiting BrennanCenter.org.
Look, there's so much more in this term, plus things to come. There, copyright, environment, Second Amendment cases. But I really, really, really want to take advantage of the opportunity to speak with you to ask some broader points. Let me start here. It's maybe the $64,000 question, but at the very beginning of Trump 2.0 and the Alien Enemies Act, it seemed like the court was going to push back on a certain notion of judicial independence and not let him have his way. Since then, there has been this really concatenation, as you spelled out, of time after time permitting Trump outsize assertions of executive power. Now, I think you and I, but many people that we respect, really see in this trend a kind of existential challenge. Like, is this going to lead to the end of the American experiment? I'm not asking you to psychoanalyze the six, but you have to imagine that they would not share that goal, even if they are bullish as can be on executive power in general. So how do you sort of read them? Do you think it's mainly strategic, don't want to, confront the president and lose? Do you think they don't think the stakes are the same as we tend to think they are? What is it?
Yeah. It's such a hard question, and I think the answer might be a little bit different depending on who in the 6 justice supermajority you're talking about. I think that the sort of pivots on some of these are, Roberts and Barrett. I think that the other four, not for identical reasons, but just for the sake of efficiency, we'll sort of group them together. I certainly don't think they are co-signing the end of American constitutional democracy or, authoring it. But I do think they have a vision of constitutional democracy that can coexist with an executive who possesses nearly unchecked power. And I think they're just fundamentally wrong if they think that is consistent with constitutional design, constitutional history. And I mean, I don't have a way to explain how they have come to convince themselves of this, but I think that the only way to really understand it is that they somehow have that the other threats that, so maybe an unchecked executive is a threat of a certain sort, but that pales in comparison to other kinds of threats that, lower courts issuing decisions constraining presidential power can constitute a larger threat. Again, I don't quite see how that squares, but I think that's a possibility. So I think to my mind, the harder question is Roberts and Barrett, who, if they choose to join with the three Democratic appointees, could literally save American democracy, I think, in my view and yours. And yet they have so far not stepped up to the task of acting as a bulwark against this president who seems
Barrett blithely says, the Constitution is well and good. Thank you, Justice Barrett.
It's been hard to swallow that, on the book tour. And and also that I don't know what a constitutional crisis would look like, she said, and I just want her to look around. And so that, I think, is one possible answer, that she's just seeing the world through different filters and different kind of info ecosystems, kind of silos than we are. And so things look much better. But if you see the things happening on the ground in cities like Portland and Chicago, even if your perspective on who's at fault is different, I don't see how you can fail to see that something incredibly significant and deeply disturbing is happening. So I think with Roberts and Barrett, there's a couple of possibilities. One is they are trying to hold their fire for the big one. And I don't know what they think that is or why they think they will be heated if they try to check him then. But I think that they may think that that is the play. They may think that all this is overstated and that we have sort of cycles of presidential power expansion and contraction, and that things moved too far in the direction of contraction, although I think they thought that Biden was too powerful, so I'm not quite sure how they square that. But that somehow this is a healthy corrective, and that somehow the lower court piece of it is, I think, what I find the most difficult to get my head around, because the sort of honor among thieves among federal judges has long been powerful enough that you just would always think the Supreme Court would at least, out of institutional loyalty, get the backs of lower court judges 100%. Who are doing their level best, to quote Roberts in a different context, to get it right under very difficult circumstances. And yet again and again, you see the Supreme Court throwing them under the bus. And I think it's incredibly disheartening for them, understandably.
Oh, my gosh. I just want to add a couple little things. First, a war story of sorts. I was actually at the department when Roberts was the Deputy Solicitor General. And, I don't have a rich record here, but I think, my general objection to the Supreme Court, at least I tell myself, it's not conservative versus liberal. It's how they are up. They have a certain camp and an allegiance to a kind of set of beliefs that grew up in the 80s. But anyway, I am here to report that at least at that point, Roberts was all in on the, executive power and growth of it, et cetera. And that has, informed me since. Is any case safe? Obergefell, New York Times versus Sullivan, Griswold, Mapp versus Ohio. You hear a lot of talk these days about how the true intellectual leader of the court, I think there's reasons to doubt this, but nevertheless is Justice Thomas. And he has certainly laid out, has Justice Thomas, a total wrecking ball of an agenda for court precedents for dating over 100 years. With that the case, do you have any sense about whether he is the now current intellectual leader, but also whether that means he's called for reconsideration of New York Times versus Sullivan? Obergefell seems to fall under the rationale of Roe's overruling, but we'll see whether they would cabin that off, same as they would the Fed. Griswold too, and then incorporation he's spoken to. What's your thought? I'm not asking you to predict. I'm asking you to opine about what might be off the table with these six.
Well, I think you're right to identify all of those as in some degree of danger. I think it's right that, Thomas has been critical of all of them, and Thomas is contemptuous of stare decisis. He's contemptuous of precedent with which he disagrees. And just the hubris in that, the sort of way he did an interview with Jen Mascott last week in which he talked about stare decisis and just says basically we don't have to abide by precedent if it's really stupid. And it's just
the Constitution, yeah.
Yeah, or if it gets the Constitution wrong enough, right? That's all we have allegiance to. And he's got a pretty idiosyncratic view of the Constitution, but it is one with in growing support. So, I think Sullivan is very vulnerable. I think the court has thankfully passed on some opportunities to take up a case that actually squarely presents the question of the future of New York Times versus Sullivan, the case that provides relatively broad First Amendment protections to good faith mistakes by members of the media and others in criticizing or reporting on public figures. And I think that it's been in the crosshairs for quite some time. I think Griswold is vulnerable, honestly. I actually think that at the end of the day, I don't see them actually taking the final step to overrule Obergefell, largely because of the kind of, pragmatic Fed reasons that we were just talking about. Right. It would be wildly disruptive.
It's not polite. Yeah.
It would, right. And that's if they're not doing what is recognizably legal reasoning, it becomes less and less clear what the point of the Supreme Court is if it's not doing anything different from the officials we elect to channel popular will. But I think that's more and more how they look. And I think that neither you nor I have gotten to that position cavalierly, but the evidence is mounting. But I will say that I don't think they would overrule Obergefell, which hopefully is comforting to people, but I certainly don't think that it would have 0 votes, and I think it could have as many as 4. But I think at the end of the day, I think it probably wouldn't have 5, but I am not 100% certain of that.
Kate Shaw, so great to be with you. I hope we can talk more as this certain to be blockbuster one way or another term unfolds. Appreciate your time. Good luck, as always, with the great Strict Scrutiny podcast, and hope to see you soon.
Thanks, Harry. Always good to talk to you.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.